along with Gideon versus Wainwright, we have a couple cards. Actually, it's three of them. They're pretty short. We should do this pretty quickly, but they have to do with rights that you have, or the rights of the accused, I should say, that have come through some different Supreme Court cases, and also just things that are developed legally in our system. And so some things that the Supreme Court has ruled on. So first off, we have 3.17 Miranda Rule. And you've probably heard of your Miranda rights. That's what this is talking about. And this came from a famous case, Miranda versus Arizona. This is not a required case that we have to fill out a Supreme Court doc, but you do have to understand the idea of the Miranda Rule. All right, here we go. One, so Miranda versus Arizona, 1966. Miranda versus Arizona, 1966. A little background on the case that you need. This guy named Miranda confessed to a crime without the police explaining his Fifth Amendment rights. So his right that against self-incrimination, for example, his right to a lawyer when he's being questioned. None of these things were explained to him. The Supreme Court overturns the conviction. So Miranda walks because he didn't get his rights read to him. And so what this ends up meaning, the meaning of all this is that the Fifth Amendment, which includes the right to counsel, the right to remain silent, things like that, it requires police to advise the suspects of their right to remain silent against self-incrimination and to obtain an attorney during questioning. So that's the main thing. That's what your Miranda rights are, that the police have to explain that before they start questioning you. And if they don't, then the conviction can be complete, or any of the evidence that they get from that can actually be thrown out of court. All right, cool. So that's that one. If you need to pause, pause. All right, public security exception 3.18. So now there's an exception to Miranda. So the Supreme Court has ruled that there are times when you cannot give Miranda rights and it's okay. And that's in an extreme situation where you're afraid someone's going to be shot or killed or something, and the police have to hurry. And if they forget to do Miranda rights in that case, that's okay because there's like public safety in question here. So this is a Miranda Rule exception. Okay, so public exception here, public security exception is Miranda Rule exception. And it's because of public safety. So it's pretty clear. Just if you know those two things right there, then you pretty much understand this this idea. And it allows an unwarned interrogation. So unwarned means you have not been warned of your Miranda rights. You've not been told of your Miranda rights. But you can actually, in this case, if public safety is an issue, then the things that you get from the interrogation that was unwarned, no Miranda rights read, they still can stand as evidence in court. Other than that, if you don't get Miranda rights, whatever's being told in the interrogation doesn't count. In this case, it would count only because of public safety. Cool, done. All right, next one, 3.19, exclusionary rule. Notice the root word, exclusion. This is where evidence is excluded from being heard in court. So the Supreme Court has ruled, like in some cases, what the police get cannot be used in court because of how they got it. And this protects the Fourth Amendment right to unreasonable search and seizure. Protects the Fourth Amendment right to unreasonable search and seizure. And the idea here is pretty simple. If evidence is illegally seized by law enforcement, meaning they didn't get a warrant, if evidence is illegally seized by law enforcement, they didn't follow the Fourth Amendment. So in violation of the Fourth Amendment, it cannot be used against the suspect in trial. So that's the exclusionary rule. Exclusionary rule. So if evidence is seized by law enforcement in violation of the Fourth Amendment, it can't be used against a suspect in trial. Also, remember, if your Miranda rights weren't read to you and you give up information, then that information can be excluded as well, and potentially even the conviction overturned. All right, awesome. That's it. Those are the three things that have to do with rights of the accused, plus Gideon versus Wainwright. Do your practices. Study and do your practices. Sorry.